Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. This week, the Supreme Court stayed a district court and the Fourth Circuit's order to immediately return Kilmar Abrego Garcia to the United States. That is, the man with withholding of removal from El Salvador due to the over 51% chance that he will be killed by gang members, who is now in a Salvadoran gulag filled with gang members due to what the Department of Justice calls an administrative error, which no one really believes is actually what happened. The Supreme Court stayed the lower court's orders, but then ruled later this week, in an order authored by the Chief Justice, that the Trump administration must facilitate Mr. Garcia's return. As of the time of this recording, no one seems to really know what that means. DOJ seems to be stalling, and the district court has ordered daily updates from DOJ as if DOJ was a 5-year-old child, given its recent behavior. The White House held a press conference today where they are clearly relying on the difference between facilitate and effectuate. So I guess this is what we've come to. Are you not entertained? The Supreme Court this week also punted on the legality of Mr. Trump's use of the Alien Enemies Act and said that to challenge it, those affected must bring actions in local district courts in a habeas setting. If, of course, they are provided enough time to do so and are not first sent to a Salvadoran gulag due to an administrative error. Immigration litigation has never been more important. So allow me to promote NILA, the National Immigration Litigation Alliance, for some of the important lawsuits it's been a part of recently. NILA is getting TROs for third country deportations for those withholding of removal recipients. That's DVDVDHS. Alongside the Northwest Immigration Rights Project. NILA is helping get work permits for TPS applicants in Mansour v. USCIS, a matter we're also involved with at KKTP. They're advocating for bond hearings, winning FOIA lawsuits on a national stage, filing amici or amicuses in the courts, doing all these things needed to protect non-citizens. Thank you, NILA. NILA also, of course, is willing to serve as a mentor and help you in your own personal litigations. Link to NILA in the show notes. 5 cases this week. Bring it on. Kicking it off with Blanco Contreras v. Bondi, published by the First Circuit on April 9th, 2025. This case is about non-LPR cancellation of removal, and it regards Mr. Blanco Contreras and his partner, both from Guatemala, and who share 2 U.S. citizen children. Having been here since 2001 and 2002 respectively, they applied for non-LPR cancellation of removal when placed in removal proceedings. They satisfied all the requirements, found the immigration judge, except the requirement that they establish that their removal will cause exceptional and extremely unusual hardship to at least one of their U.S. citizen children. The couple testified that their children, aged 15 and 9, were completely unfamiliar with Guatemala, although they spoke, read, and wrote in Spanish fluently. The second petitioner, Ms. Lopez, explained how poverty and other circumstances had forced her to leave school at age 12, and she fears similar things will happen to her children in Guatemala. Not to mention the gang and other violence, she explained. Indeed, several members of Ms. Lopez's family have been threatened and extorted by gangs, with a sister even being, quote, kidnapped by a gang and never heard from again, end quote. Most important here, Ms. Lopez testified how her 15-year-old son, known here as ABM, suffered, quote, from obesity, high cholesterol, and seasonal allergies, requiring him to maintain a diet high in fruits, vegetables, and water, and to see a doctor every 3 months, end quote. He also has a skin condition, sleep apnea, and other issues. He also has mental health issues. And this is really unfortunate, so I'm glad there's a pseudonym, but also it all must be discussed as it is the meat of the case. Quote, when ABM was 6 years old, he was touched sexually by peers in his kindergarten class, end quote. Not much was done about it by the school, but 9 years later, a 2018 psychological report noted after the assault that ABM became fearful, anxious, and upset, refusing to go to school, quote, because he was so scared of the other students, end quote. He began wetting the bed and suffers fear, anxiety, and depression, seemingly as a result of all of this, to this day. The immigration judge was not swayed and the BIA affirmed, but the First Circuit sent it back. After the Supreme Court's Wilkinson case, of course, whether agreed-to facts meet the exceptional, extremely unusual hardship standard is indeed a reviewable mixed question of law and fact. Overturning first precedent on that no less. Well, that and Guerrero-Asprilla. What is the standard, though, for exceptional, extremely unusual hardship? Well, quote, it is not so restrictive that only a handful of applicants will qualify for relief, end quote. Good to know. And the medical conditions of the children are always quite relevant. The First Circuit can also review whether the agency, quote, completely ignored key evidence, end quote. Or put another way, quote, a BIA decision that turns a blind eye to salient facts or completely overlooks critical evidence is erroneous as a matter of law, end quote. Quite the quote. The First Circuit can't, however, and, for example, review the IJ and the BIA's finding that the son doesn't suffer from a serious medical issue. That's a factual question, and it's disputed, so no review. But it's still a win here for the non-citizens. Because, quite frankly, despite the almost certain loss on the hardship challenge itself, should it have been the only challenge, the First Circuit thinks that the agency ignored important evidence, and again, that's a legal error. Didn't consider the record as a whole then, right? Back to that 2018 psychological report. A psychological professional made express findings about ABM's mental health history and the conditions and need for continued treatment. Quote, such evidence was unquestionably highly pertinent to whether petitioners made the requisite showing of exceptional and extremely unusual hardship, end quote. The BIA in turn affirmed the IJ's finding that ABM, quote, does not suffer from any serious medical conditions, end quote. But how could that be? Asked the First Circuit in so many words. Unless the IJ and the BIA ignored the psychological report. Crucially, for your similar appeals, quote, while the BIA acknowledged the existence of the 2018 report in a single-sentence summary, it did not so much as mention, let alone engage with, several key findings contained in that report, end quote. Also then, all pretty, quote, facially inconsistent with the BIA's statement that ABA has never required mental health counseling, medication, or any specialized medical treatment, end quote. How could that be? To be clear, by the way, the First Circuit also agrees, quote, as a matter of logic, that the fact that ABM did not receive mental health services certainly does not mean he did not need them, end quote, before relatively recently. Well said. Despite a few mentions, the BIA didn't really engage with the psychological report, or ABM's needs at all, much less explain how, if at all, it can be addressed for ABM in Guatemala. Quote, glaring omission, end quote, to the First Circuit, and one requiring remand. Can't ignore evidence, everyone. Thank deity for judicial review. No? Congratulations, Randy Olin, for petitioners. And that is Blanco Contreras v. Bondi. Two from the BIA this week, and here's the first one. Matter of Iskandarani, published by the BIA. This is a procedural case about appeals. Mr. Iskandarani had his initial appeal of an adverse immigration judge decision dismissed as untimely last year. He filed a motion to reconsider, which the BIA has now denied precedentially. Because you see, Mr. Iskandarani was ordered removed on September 14th, 2023, and was informed orally through an interpreter that his notice of appeal was due at the BIA on or before October 16th, 2023. 30 days, I imagine, though I have not done the math independently. The immigration court then mailed, however, what appears to be the summary memorandum of the decision, that 2 or 3 page document with checkboxes and orders, if I'm not mistaken. Mr. Iskandarani filed his notice of appeal on October 18th, beyond the 30-day deadline by 2 days, if the triggering date is the oral decision, and of course beyond the date expressly ordered by the immigration judge. But it's within the 30 days if the triggering date is the date of the summary memorandum, which was issued like a week after the oral decision. The triggering date is the date of the oral decision. Quote, when an immigration judge issues an oral decision, the 30-day appeal filing period is calculated from the date the decision is rendered and is unaffected by the subsequent mailing of a memorandum summarizing the oral decision. End quote. According to the BIA, 8 C.F.R. section 1003.38b establishes that a, quote, notice of appeal from a decision of the IJ must be filed with the board within 30 days of an IJ's oral decision, or the mailing or electronic notification of a written decision, end quote. The notice of appeal being filed on an EYR 26 form. Not for nothing as well, quote, if the last day falls on a weekend or a legal holiday, the appeal must be received no later than the next business day, end quote. If the memorandum thing is considered a written decision, then Mr. Iskandarani is right. But again, it's not, said the BIA. Quote, an oral decision is not transformed into a written decision merely because the immigration judge prepares a memorandum summarizing the oral decision, end quote. And this would remain the case, explains the BIA in a footnote, even if the IJ later sent a more substantive thing, like a generic, quote, law addendum, end quote, that some IJs use. It meant here that Mr. Iskandarani lost his case, can't file a notice of appeal or a brief, and remains ordered removed. Allow me to riff for just one moment. So, be careful, everyone. I'm actually not sure if this was the summary 1 or 2 page memorandum thing that IJs issue alongside an oral decision, but it seems to be. But also, I'm not sure if that matters. For example, if an IJ issues an oral decision and then sends something a week later summarizing the substance of the IJ's findings, I still don't think that would transform the oral decision into a written decision. In fact, I wouldn't trust anything received from a court after a hearing where the IJ disposes of claims being a written decision unless the document is expressly labeled a written decision. Maybe I'm being paranoid, but there are worse things to be in this day and age where 30-day deadlines are so strictly enforced. If you're confused, I'd say call the IJ's legal assistant for clarification. But they took down those numbers from the public websites. I've still got the most updated secret nationwide document if you want it, though. For a fee. An exceptionally high fee. Tariffs, am I right? And that is matter of Iskandarani. Next we have matter of OARG, published by the BIA. This case is about particular social groups and nexus. And so it begins. The respondents are an unmarried couple from Colombia and their daughter. They fear the Revolutionary Armed Forces of Colombia, the FARC, one of the many now expanding groups worldwide labeled terrorists by the U.S. Department of State. FARC's been included for quite some time now, though. The lead respondent was a police officer who operated against the FARC in 2022. The next day, after their operation, FARC members boarded a bus that the lead respondent was traveling home on, stated that they were looking for police officers, and then beat the respondent and 8 others with rifle butts. Quote, the respondent was hit in the chest, back, and mouth, resulting in a broken tooth. The respondent escaped into the jungle and later boarded another bus home. End quote. When he reported that to police, the very police that he worked for, they offered him a vacation, but not protection because they didn't have the men. Quote, while recuperating at home, the respondent received a threatening document written with newspaper clippings that said he had a beautiful family, but it was a pity that they were already dead. The document also included photos from the respondent's personal phone and indicated that it was from the FARC. End quote. He resigned from the police for this reason not long after. He and his family moved to Bogota, where he received another threatening phone call, and shortly thereafter departed for the U.S. with passports and visas, it seems. As relevant here, the lead respondent applied for asylum as a member of the particular social group, quote, former police officers of Colombia, end quote. Before getting to the facts, I would just like to take a step back to ask why U.S. law has developed such that an individual like this does not warrant U.S. protection. He has, after all, credibly put his life and that of his family on the line to combat a group that the U.S. believes is so dangerous that it's a terrorist organization and has wreaked havoc in the country of a U.S. ally for decades. Not to mention the drugs. The lead respondent was beaten savagely and only stopped his fight against the terrorist organization when the very police that he worked for said they couldn't protect him. The respondents here did not win their case before the IJ or the BIA either in this decision. It's all about particular social groups. So we shall leave reality on the ground and enter the ivory tower of semantics. Particular social groups must be immutable, particular, and socially distinct. The group former police officers of Colombia describes a past experience, and so do the BIA, quote, by definition cannot be changed, end quote, making it immutable, the first of the 3 elements. And heck, the BIA even assumed here that the group is also socially distinct and particular. Good to go, right? No, because of nexus. Even with a valid particular social group, the harm suffered or feared still has to be on account of that particular social group. Bit of a problem here, quote, the respondent acknowledges on appeal that the FARC harmed him because of his actions as a police officer, end quote. But he's not a police officer anymore, right? After he resigned, he simply received 1 threatening phone call, explains the BIA, when he was a former police officer. So then, with no past persecution finding, on to a well-founded fear of future persecution based on the membership in the group former police officers. On this, the BIA cited and relied on its 2023 decision matter of MRMS, much lamented on this podcast at the time on episode 188, whereby, quote, to establish eligibility for asylum or withholding, an applicant must prove that the persecutor's motive for the harm is the desire to overcome the protected characteristic or otherwise based on animus against the group, end quote. The Sixth Circuit arguably said that this portion of MRMS is wrong in Mazarregos Rodas v. Garland, episode 230, but the BIA did not mention that, and in any event, this case apparently arises in the Ninth Circuit. So let's apply that MRMS rule, reasoned the BIA. The BIA didn't think that the record shows that the FARC really cares about former police officers. True, matter of CA from 2006 holds that, quote, reprisals against former police officers as a class may give rise to asylum eligibility, end quote. Perhaps that's why the BIA here assumes that the group is socially distinct in particular. And that means that this argument is far from a dead one. It's just not the case here, said the BIA. Quote, reprisals against police officers based on specific conduct or official acts are not on account of being a former police officer, end quote. Unless, of course, I guess the record shows that the assailants really hate former police officers. With that asserted particular social group dealt with, the BIA summarily affirmed denial of the lead respondent's other proffered group, quote, men in Colombia the government is unwilling or unable to protect, end quote. Impermissibly circular, said the BIA, ironically enough quoting the Sixth Circuit. although not mentioning Aleman Beloso v. Garland, episode 238, or even the Sixth Circuit, and Tista Ruiz de Ajulip v. Garland, episode 224, among others. Interesting discussion in footnote 5, though. The BIA believes that in the Ninth Circuit, whether the risk of harm tanks a particular social group depends on whether the risk of harm is a, quote, intrinsic element of the group definition, end quote, rather than merely descriptive. If the risk of harm is an intrinsic element, says the BIA, reviewing Ninth Circuit case law, then the group is impermissibly circular. That's Diaz-Reynoso v. Barr from 2020, but I do wonder what Aleman Beloso said in episode 238. Haven't read that one in a few weeks. Don't get me wrong, I don't love this second group. Just saying, the anti-circularity stuff is complicated. Summarily dismissing the cat claim, the BIA dismissed the appeal. Some thoughts. Why not assert both particular social groups? That is, Colombian police officers and former Colombian police officers. You can, and to be honest, kind of have to, under BIA precedent, assert as many particular social groups as you can before the IJ. Seems like there's a decent chance that the lead respondent here could have got a past persecution finding based on his membership in the particular social group of police officers in Colombia. With a past persecution finding, the burden would then shift to DHS to rebut. Let them argue that things have changed for the lead respondent such that he no longer has a well-founded fear, right? But by limiting the initial particular social group asserted, the respondent kind of gave DHS a bit of a gift and made denial easier. Seems to me, anyway. Don't get me wrong, it's weird that any of this matters when everyone agrees that the lead respondent has good reason to fear for his life due to his work combating a U.S.-designated terrorist organization. And don't get me wrong, I saw the BIA's footnote trying to get in front of this by stating that, quote, employment is not immutable, end quote, and cops take risks, so tough luck, but even the BIA recognizes that circuit case law exists that can make employment or similar activities immutable when that employment is, quote, fundamental to his identity or consciousness, end quote. We are very much back to fighting every nuance of every asylum element, non-citizens councils. Brush up on your circuit's asylum law. This is just the beginning. And that is a matter of OARG. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial College in Kansas City. Get ready for a transformative experience at the annual Immigration Court Trial Advocacy College, now hosted by the Pen and Sword, formerly the clinic at Sharma Crawford Attorneys at Law. That's friends of the pod and friends of the Kevin, Rekha and Michael Sharma Crawford, excellent immigration attorneys. The college convenes from April 24th to 26th and will focus on detentions, bonds, and release for 3 action-packed days of hands-on practical training and expert insights. This is not your average Talking Heads program. This is real cases, real witnesses, and real courtrooms designed to give you a real edge in your immigration practice. Put another way, this isn't just another training. It's an opportunity to transform your practice and fight for justice in a way that matters. Sharpen your skills, amplify your voice, defend immigrant rights like never before. Don't miss out, because space is limited. Check out all of the links to Rekha and Michael Sharma Crawford, their firm, and the Pen and Sword in the show notes. And if you want to get a bit of a discount for the Trial Advocacy College, click on the link in the show notes or use promo code IMREVIEW2025. That's IMMReview2025. Keep up and join the good fight. Welcome back. With Thankarasa v. Attorney General of the U.S., published by the Third Circuit on April 10th, 2025. This is a very interesting one about asylum. Split decision, with Judge Roth dissenting. Mr. Thankarasa is an ethnically Tamil citizen of Sri Lanka. Pretty big history of ethnic tensions and civil war there. Mr. Thankarasa participated in a pro-Tamil protest and was arrested. Several weeks later, unknown people came to his house, threatened to kill him, and tried to kidnap him. He called the police, who arrested him, beat him, called him a terrorist, and interrogated him. He fled Sri Lanka. Very well might be a viable asylum claim. Except, to the IJ at least, for what Mr. Thankarasa did next. He hired a smuggler who it seems maybe got him a false passport, whereby he was smuggled to Europe and spent 2 years in 4 different countries. He never applied for asylum in any of them. To get to America, he was definitely given a genuine French passport belonging to someone else that he used fraudulently. When he came to America through an airport, I believe, a border officer did not believe that Mr. Thankarasa was that someone else, and initiated removal proceedings. But actually, it's asylum-only proceedings, right? It's a French passport, so visa waiver program, meaning he either has to return to France or claim asylum in the U.S. He claimed asylum, so it's asylum-only proceedings for Mr. Thankarasa. Asylum-only proceedings being a misnomer, of course, because he can also receive withholding of removal or cat protection in those asylum-only proceedings. Also, just an aside, there's an interesting legal question out there about whether someone who unlawfully enters through the visa waiver program and who isn't even a citizen of that country and uses a false passport actually gives up their right to full-on Section 240 proceedings. Because they were never eligible for visa waiver in the first place, they're not even part of the country. But I'm not sure that a circuit has bit on that argument yet. Anyway, the IJ denied asylum as a matter of discretion, a somewhat rare thing to do, but granted Mr. Thankarasa withholding of removal. So unless he has a Hispanic-sounding name, which is unlikely, or wears Chicago Bulls hats, he's probably safe from that Salvadoran prison. Be careful, Mr. Thankarasa. Mistakes do happen, and the most powerful country in the history of the world, and who is also all but paying for that Salvadoran prison, is unable to get people out of said prison. It's just too delicate of an international relation. But presumably, Mr. Thankarasa shouldn't be going anywhere. He has withholding of removal. But he wants that sweet, sweet asylum. Only path to a green card after all. And as we're now seeing, withholding might not be the protection we all assumed it was, given that it was always permissible to deport someone to a third country, assuming that the proper procedures were followed. As we've seen on other Sri Lankan pod cases, 8 C.F.R. section 2008.16e requires immigration judges to reconsider an asylum denial when they grant withholding of removal. That is, when asylum is denied as a matter of discretion. And in matter of TZ from the BIA in 2007, the BIA held that family unity is a critical factor to be considered in this reconsideration. But Mr. Thankarasa was a young man when all this happened, and he has no wife or children. So the IJ did not change its asylum denial discretionary decision. The BIA affirmed, as did the Third Circuit majority. Asylum is, of course, discretionary, but case law in pretty much all circuits holds that, quote, the danger of persecution should generally outweigh all but the most egregious of adverse factors, end quote. That said, discretionary analyses are always kind of mushy, explained the court, governed by the 1987 decision matter of Pula, particularly where the asylum applicant has spent significant time in other countries before coming to the United States. All the things that Mr. Thankarasa did were sufficiently, quote, egregious, end quote, to the court, as required under Third Circuit precedent. That is, the fraud and the stays in third countries without applying for asylum, quote, thoroughly reasoned decision, end quote, from the immigration judge, stated the Third Circuit. This despite the fact that apparently the IJ and the BIA didn't mention, quote, the certificates of good character and country condition materials submitted with his asylum application, end quote. Might be an error, considering that discretion is always a totality of the circumstances analysis, right? But to the Third Circuit, quote, the IJ demonstrated that he reviewed the record, balanced what he deemed to be the relevant factors, and indicated how they supported his decision, end quote. Immigration judges are exceptionally overworked, and they don't have to mention everything, every time, explained the court, particularly because when it comes to asylum discretion, quote, there is no need to evaluate every factor enunciated by case law, end quote. I guess at least when the adverse stuff is bad enough. So Mr. Thankarasa stays, but he doesn't have asylum, necessarily permanent protection, or a path to a green card. Judge Roth dissented, believing the BIA applied a heightened standard to Mr. Thankarasa and made a variety of other errors too. Likely thinking about some cases discussed on the pod, Judge Roth concludes by stating, quote, one need not go as far as the Second and Ninth Circuit's categorical approach to conclude that entry fraud is not a most egregious adverse factor, end quote. That is, fraud can sometimes be forgiven, it seems, to Judge Roth, when it's connected to a viable, legitimate, claimed fear of persecution. But it was not meant to be for Mr. Thankarasa. And that is Thankarasa, the Attorney General of the U.S. And so we've come to the end of the road. You belong to me. I belong to you. We all belong to the Fourth Circuit, with Chavez v. Bondi, published by the Fourth on April 10th, 2025. This case is about theft-type crimes involving moral turpitude, brought post-Loper Bright. So it's important. The non-citizen did not succeed in a long one. Ms. Chavez has lived in the United States since entering without authorization in 2000. In 2011, she was convicted of Virginia petty larceny. Virginia Code Section 18.2-96, to be specific. She was removable for entering without authorization, but sought non-LPR cancellation of removal, but you can't get that either if the Virginia offense, petty larceny, is a crime involving moral turpitude. And IJ held that the crime was. Incorrectly believing itself bound by a Fourth Circuit case that did not actually hold that the crime was a CIMT. The BIA cleaned that up, but still deemed the crime a CIMT. In so holding, the BIA held that Virginia petty larceny involves only, quote, reprehensible conduct, end quote. Which I must admit I've never quite understood. Don't get me wrong, don't steal stuff. But low-level theft is reprehensible? If that's reprehensible, then all crimes are reprehensible. And maybe that's true, maybe it is. But if that's true, nearly everything's a CIMT, which of course is not true. But that is the logic, so perhaps that's why the CIMT definition unconstitutionally makes no sense, etc., etc. I mean, in Virginia here, we're talking about taking goods less than $200, with seemingly no limiting principle. The Fourth Circuit affirmed the CIMT finding. First off, the Fourth Circuit flat out said what the Ninth Circuit kind of came around to as well recently. Due to the Supreme Court's language, quote, Loper Bright doesn't wipe away the results of our prior decisions, deferring to the board's reasonable interpretations of what constitutes a crime involving moral turpitude. But it does mean that any board guidance serves only as persuasive authority, end quote. So I guess if the Fourth Circuit had held that the crime was a CIMT in the past, maybe it can't reanalyze that now, even if the prior decision relied on Chevron deference. But if it didn't, it can review the issue again, with other similar decisions providing mere non-binding guidance, including the precedential BIA decisions. Turning first to what is the CIMT definition in the Fourth Circuit, the court has now defined it as such, admittingly the same as it did pre-Loper Bright. CIMTs describe crimes that, quote, must involve conduct that not only violates a statute, but also independently violates a moral norm, end quote. That in turn means, quote, a culpable mental state and reprehensible conduct, end quote. So like fraud crimes aren't per se Fourth Circuit? must independently involve reprehensible conduct, as in the 11th Circuit? Seems the case to me. Here, Ms. Chavez first attacked the mental state required of the Virginia offense. Quote, she argues correctly that to satisfy the mental state requirement, the crime must have as an element an intent to achieve an immoral result, end quote. That is to be a CIMT. Criminal negligence won't do, explains the Fourth Circuit. Ms. Chavez argued that that was the case here in Virginia. Quote, a defendant can be convicted of larceny in Virginia for negligent conduct because she can raise the claim of right defense only if she mistakenly but reasonably believed that the stolen property had been abandoned, end quote. That affirmative defense fails, though, if the defendant, quote, unreasonably believed that the stolen property had been abandoned, end quote. So putting that all together, it means to Ms. Chavez that someone can be convicted through criminal negligence. They'd lose out on the affirmative defense to conviction based on their unreasonable belief that the stolen property had been abandoned. Confusing, right? Even more so because I must note here that contrary to Oyle's argument, this is a viable argument in the Fourth Circuit, even if some other courts have rejected it. Quote, we consider affirmative defenses that negate an element of the crime because the government retains the burden of proof to show such defenses don't apply, end quote. That is in criminal court. So we've got this complicated affirmative defense type argument in which Ms. Chavez is trying to show that because of this affirmative defense, the mens rea element has been watered down to mere criminal negligence in petty larceny in Virginia. That's me unpacking it. The Fourth Circuit spent some time, quote, unpacking, end quote, this argument and discussed a lot of case law, eventually rejecting it. To summarize, though, Virginia case law has developed such that to convict, a jury must find that the defendant committed the larceny, quote, with the intention to deprive the owner thereof permanently, end quote. So how can you have the intent to do something negligently? Ask the court. But then how can this affirmative defense thing come into play? Well, explained the Fourth Circuit, it applies where the defendant has a good faith belief that the property is abandoned. Still have to intend to deprive the owner, I guess, but you just don't think that the owner cares anymore? But remember again, that affirmative defense does not apply if you have an unreasonable belief as to the abandonment. Nonetheless, the Fourth Circuit does not read that as disrupting the specific intent element required to convict. If it was an element, it would in fact make the crime a negligence crime, which of course is what Ms. Chavez is trying to argue is possible. But to the Fourth Circuit, in admittingly murky waters, it believes it more likely that the, quote, reasonable basis language is a threshold determination as to whether there is sufficient evidence to allow an instruction on abandonment to go to the jury, end quote. Are you still following? It's not so much about altering the elements to the Fourth Circuit. It's about permitting a judge to conclude whether or not a jury can even hear about the abandoned property affirmative defense. Because after all, we don't want to be confusing juries. If I went through all the arguments made and rejected in this one, we'd be here all day and your heads would be spinning like mine. The Fourth Circuit really just can't get over the fact that Virginia requires an intent to deprive showing, which of course is a sufficient elemental mens rea, even if the affirmative defense stuff makes it weird. So mens rea argument rejected. If that weren't enough, of course, Ms. Chavez also argued that the petty larceny offense, involving, by definition, no more than $200 worth of property, doesn't categorically involve reprehensible conduct, as the CIMT definition requires. Something I've been advocating for at all of these conferences, albeit with no real case law in support. And the Fourth Circuit didn't bite. It notes that theft crimes have been deemed CIMTs for more than 80 years. Still, it's the court's call under Loper Bright, but that's not something to sneeze at, I suppose. Federal courts have for years also followed suit, even with petty larceny. And although it's a different definition, Virginia's highest court has deemed petty larceny a CIMT for witness impeachment purposes. Smart argument, Oyle, albeit not directly on point. On this as well, the Fourth Circuit provided, quote, due respect, end quote, to the BIA's most recent CIMT theft type definition in matter of Diaz-Lizarraga, which had held that theft crimes are almost always CIMTs. Give Diaz-Lizarraga a read if you want a refresher. That Virginia petty larceny can involve a conviction for a de minimis taking is besides the point to the court. It, quote, would require courts to draw an artificial line on what monetary amount is enough to trigger a finding of moral turpitude, end quote. But I don't know, courts draw lines all the time. Problematic too, though, here to the court, where the BIA has with due respect held that, quote, a taking or exercise of control over another's property without consent is itself a potentially reprehensible act that is inherently base and contrary to the moral duties owed between persons and to society in general, end quote. I don't know, guys. I'm convinced by Miss Chavez. But I came in convinced already. Seriously though, what crime is not morally reprehensible if stealing a $5 candy bar from a convenience store is considered reprehensible? Don't do it. But where is the CIMT line? Seeing its opportunity and deciding not to take it, the court states that, quote, the Supreme Court in Loper Bright may have instructed us to review agency interpretation with a keener eye, but it didn't write off respect for settled, consistent, and persuasive precedents, end quote. Finally, Ms. Chavez argued that the CIMT definition can change, which I'm pretty sure is true, and, quote, society no longer views petty larceny as reprehensible, end quote. Even cites to a Simpsons episode. The Fourth Circuit wasn't having it. Seems like it didn't really want to consider the argument, to me at least, quote, to recognize and give credit to such an alleged normative shift in how society now views de minimis takings, we would need clearer and more objective evidence than this record presents, end quote. So you're saying there's a chance. Ms. Chavez did not succeed, though, and remains removable. Virginia Code Section 18.2-96 is a CIMT. And that is Chavez v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.